The Meeting of June 5, 1934. Like American immigration and citizenship law, American anti-miscegenation law was very old, dating back to a pioneering Virginia statute of 1691. The American tradition of banning race miscegenation, like American immigration and second citizenship law, was attracting European attention well before the Nazis came on the scene. This was another area in which America was a recognized global leader, with prohibitions both old and new. American states continued to introduce anti-miscegenation statutes in the early 20th century. This was an active area of American racist lawmaking. And as with immigration and citizenship law, German lawyers and policymakers had a history of great interest in American anti-miscegenation law that long predated the Nazi period. The first flurry of German studies of the American approach dated to the era of pre-World War I German imperialism. Beginning in 1905, German colonial administrators in Southwest Africa and elsewhere instituted anti-miscegenation measures intended to safeguard the purity of the German settler population against mixing with the natives. These racist measures were unparalleled among other European colonial powers, but they had a model in America, and German colonial administrators investigated that model eagerly, as Goethel has shown in important work. Their efforts included voyages through the southern states, commissioned reports from diplomats, consultation with the Harvard historian Archibald Cary Coolidge, and more. And the colonial archives include detailed reports on U.S. law. Here, once again, late 19th and early 20th century America struck Germans as a country at the forefront of the creation of a conscious unity of the white race. German interests in American anti-miscegenation law did not fade in the 1930s. The anti-miscegenation measures that pre-war colonial administrators produced may or may not have directly influenced the Nuremberg Laws. Historians disagree, but there can be no doubt that the drafters of the Nuremberg Laws studied American law just as eagerly as their colonial predecessors did. America was the great model in 1905, and it remained the great model 3 decades later. It is now time to turn to the details of the stenographic report of the June 5, 1934 meeting of the Commission on Criminal Law Reform. This report, preserved in the archives in 2 separate versions, was first published in 1989. The meeting it transcribed brought together 17 lawyers and officials under the chairmanship of Justice Minister Gertner. The attendees included Lösner, the reporter on the Jews, Freisler, the future president of the Nazi People's Court, at the time a state secretary attached to the Ministry of Justice, along with other lawyers and medical doctors from the Nazi ministries, including 3 radicals who had participated with Freisler in the drafting of the Prussian Memorandum. The meeting was called to respond to the demands that the memorandum had made, and the principal legal questions on the table were whether mixed marriages should be criminalized, what form any such criminalization should take, and how to manage the challenging business of defining Jews and other members of disfavored races, along with a few other matters that I will leave to the side. The transcript is a record of clashes, though generally studiously polite ones, between the radicals who had worked on the memorandum and juristic moderates led by Justice Minister Gertner. At the time that the meeting occurred, the Night of the Long Knives had not yet taken place. The meeting thus dates to the last weeks before the mask had fully fallen from the face of radicalism in Nazi Germany, and the transcript records a last moment of moderate success. Gertner and the other moderate lawyers present did not quarrel with the goal of institutionalizing anti-Jewish policies. These were, to say it once again, no heroes of resistance to Hitler, but they did work to fend off extremes of criminalization. Some of them suggested that perhaps a campaign of public education and enlightenment might gradually succeed in ending the evil of sexual mixing without formal criminalization. If there was to be criminalization at all, Gertner insisted it must be done on the basis of the only suitable juristic model, the criminalization of bigamy. That meant that there were only to be prosecutions in cases where a Jew had engaged in malicious deception of an Aryan partner. Other lawyers present pushed an even milder line. Eduard Kohlrausch, a prominent professor of criminal law, argued that criminalization of any kind would be actively counterproductive. Lösner maintained, in line with traditional juristic teachings, that the very concept of a Jew was so elusive that the radical program was impracticable. For their part, the radicals present argued occasionally in browbeating tones that the criminal code must be revised to reflect the fundamental principle of National Socialism that was the harsh legal enforcement of racism. But at the end of the day, they were forced to give up on the full-scale implementation of the Prussian Memorandum. Some of them admitted that diplomatic pressures made it impossible for the moment to carry out the measures that they deemed necessary. The objections of so many countries to targeting colored races were too grave. Freisler, while insisting fervently on the need to remain faithful to the mission of National Socialism and defending the use of the term colored, yielded to the technical objections of the conventional jurists. For the moment, there could only be the creation of the offense of malicious deception. At the same time that the radicals were making these concessions, though, they were also making unmistakably threatening noises. There were menacing references to the political agitation taking place outside the meeting. Freisler hinted, courteously but ominously, that the ultimate judgment would have to be made not by the professional jurists present, but by the political decision of the Nazi leadership. If the moderate lawyers were able to hold the line at this meeting, it is clear enough in retrospect that the political forces were arrayed against them. And what about the place of American law already cited by the Prussian Memorandum? The dismaying answer is that this pivotal meeting on the road to the Nuremberg Laws involved repeated and detailed discussion of the American example from its very opening moments, and that American law was championed principally by the radicals. After a brief opening statement by Gertner, the meeting heard from two officials who had been charged with preparing reports for the commission. The first was Fritz Grau, a party member, later to rise to high rank in the SS. Grau, one of the men who had participated in the drafting of the Prussian Memorandum, took a hardline view of the need for criminalization. But, like other hardliners present, he conceded that it was not yet possible to implement the program of the Prussian Memorandum. Painful though it was for him to say so, he declared for the moment foreign relations made it necessary to hold off on including race protection explicitly in the criminal code. But that did not mean that Grau was ready to abandon the field to the forces of moderation. He was still determined to lay out the unsparing Nazi case against the Jewish menace. Grau acknowledged there were some lawyers and officials who believed that a program of education and enlightenment would suffice as an alternative to criminalization. Education and enlightenment was, however, he said, an unacceptable approach. Like other Nazis, Grau linked the question of sexual mixing to the question of citizenship, just as the two would be linked at Nuremberg. Here is the record of his words. The party program of 1920 determines that citizens may only be persons of German descent and that foreign races should be subject to a guest right. The program thus intends that the new German state should be built on a racial foundation. In order to achieve this goal, a great deal has taken place over the last years. An effort has been made to root out the racially foreign elements from the body of the folk, first of all by striving to deprive them of any influence, to drive them out of the leadership of the state, as well as out of other influential positions and professions. All these measures have undoubtedly brought us a step forward, but they have not achieved and could not achieve an effective quarantine separating the racially foreign elements in Germany from the people of German descent. For foreign policy reasons, the necessary law could not be instituted, a law that would prevent all sexual mixing between Germans and the foreign races. Now, one could perhaps say, and here I come to the second question posed by Mr. Minister of Justice, that this goal could be achieved gradually through education and enlightenment without any express law. It was at this point that Grau turned to America, the homeland of race-based law. He noted that Jim Crow segregation, already put on the table by the Prussian Memorandum, might seem to offer a possible model for an approach founded on education and enlightenment. However, it was his view that segregation was not suitable to German circumstances. Other Völker, too, one might say, had achieved such a goal, that is, the elimination of race mixing through education and enlightenment, essentially through social segregation. That statement is, however, only correct with certain provisos. Among these other Völker, I am thinking chiefly of North America, which even has statutes along these lines. The problem is a different one, namely the problem of keeping members of colored races at bay, a problem that plays as good as no role for us in Germany. For us, the problem is sharply directed against the Jews, who must be kept enduringly apart, since there is no doubt that they represent a foreign body in the folk. It is my conviction that just taking the path of social segregation and separation will never achieve the goal, as long as the Jews in Germany represent a thoroughly extraordinary economic power. As long as they have a voice in economic affairs in our German fatherland, as they do now, as long as they have the most beautiful automobiles, the most beautiful motorboats, as long as they play a prominent role in all pleasure spots and resorts and everywhere that costs money, as long as all this is true, I do not believe that they can really be segregated from the body of the German folk in the absence of statutory law. This can only be achieved through positive statutory measures that forbid absolutely all sexual mixing of a Jew with a German and impose severe criminal punishment. Thus, riveting to read, a hardline Nazi view on Jim Crow segregation. Segregation would simply never succeed in Germany. German Jews, unlike American blacks, were too wealthy and arrogant. The only hope was that they be put down by severe criminal punishment. Jim Crow segregation, such was this striking Nazi judgment, was a strategy that could work only against a minority population that was already oppressed and impoverished. It deserves emphasis that Grau went out of his way to dismiss the option of Jim Crow segregation. The fact that he felt obliged to do so suggests clearly enough that there had been debates about American law behind the scenes before this meeting took place. Somebody had been making the case for a German Jim Crow as the foundation of a comparatively mild approach aiming at education and enlightenment of the population. Indeed, we shall hear momentarily that Grau was not the only participant at the meeting to address the possible attractions of Jim Crow. When Grau had finished his report, Kohlrausch then followed with his own distinctly more moderate one, which pled the case against criminalization. Minister of Justice Gertner then took the floor to open the general discussion. His intervention revealed that the ministry had been working hard to collect information on the very American example that Grau had brought up. I am very grateful to the two gentlemen for their reports. If I were to express a few thoughts myself, they would be these. When it comes to race legislation, it was naturally very attractive to look around in the world to see how this problem has been attacked by other Völker. I possess here a thoroughly comprehensible synoptic presentation of North American race legislation, and I can tell you right away that the material was rather difficult to find. If any of you gentlemen takes a personal interest, I am ready to make this breakdown available to you. Apparently, Gertner displayed a Justice Ministry memo surveying the law of the American states. Then, as now, collecting information on all of the states was rather difficult. Nevertheless, the ministry had been able to extract what German lawyers always seek, a Grundgedanke, a fundamental idea. The material gives an answer to the question of what form race legislation in the American states takes. The picture is as variegated as the American map. Almost all American states have race legislation. The races that must be defended against are characterized in different ways. Nevertheless, a fundamental idea can be very easily extracted. The laws list Negroes or mulattoes or Chinese or Mongols in motley variation. They often speak of persons of African descent, thus addressing the issue historically, by which they mean Negroes, and there are a few sections which make positive reference to the Caucasian race. That is not uninteresting, since I believe there is a jurisprudence on the question of whether Jews belong to the Caucasian race. At that point, Gertner apparently turned to his deputy, Hans von Dohnanyi, perhaps the most fascinating and certainly the most heroic of the moderates present. Dohnanyi, the son of the Hungarian composer Ernő Dohnanyi and brother-in-law of the dissident theologian Dietrich Bonhoeffer, joined the Nazi Justice Ministry in June 1933. But only a few weeks after the June 5, 1934 meeting, he became a clandestine opponent of the regime, embarking on the dangerous project of collecting and indexing documents that he hoped would someday be used for a prosecution of the Nazi leadership. Eventually, he would be executed for participation in the resistance against Hitler. In early June 1934, however, Dohnanyi was still a government legal official at work on the creation of anti-Jewish legislation. Evidently, he had had some of the responsibility for the ministry's research, for he supplied an account of American race jurisprudence as to Jews. State Attorney Dr. von Dohnanyi. Yes, the jurisprudence speaks of the Caucasian race simply in opposition to all colored races. That is to say, it speaks of the white race, and since Jews belong to the white race, they are reckoned among the Caucasians. Reich Minister of Justice Gertner. That is the jurisprudence of the highest courts? State Attorney Dr. Dohnanyi. Yes. Gertner. One can see from that, and from the map, how correct the observation of Mr. Vice President Dr. Grau was, that this legislation is not directed against Jews, but protects the Jews. That gives us nothing to work with. The aim of an American-style approach would be the contrary of our own. If that were all that the participants had had to say about American law, we would have to conclude that the American model, carefully researched by the Justice Ministry, had proven of no value to the Nazi regime. But Gertner did not stop with the observation that American legislation was not directed against the Jews, and he would not be the last to raise the subject. He continued with his presentation of the ministry memo, turning to what was interesting about American law. The ministry's research had turned up many facts about American anti-miscegenation statutes. Then it is interesting, Gertner reported, to see what legal consequences are attached to sexual union. That, too, is variable. All sorts of expressions appear illegal and void, absolutely void, utterly null and void, prohibited also sometimes appears. From these shifting and not very sharply juristically defined words, it can be seen that civil law consequences attach in all cases, and criminal consequences in a great number of cases. This was the critical point. In America, there were criminal consequences. The American example spoke directly to the great question that divided the lawyers present at the meeting. It showed that the criminalization of racially mixed marriages, even outside the case of bigamy, was not unprecedented. That fact cannot have been welcome to Gertner, who opposed such far-reaching criminalization, and he quickly made an effort to neutralize the American example. Whatever American statutes might say, Gertner rushed to argue, it could not really be the case that Americans routinely imposed such criminal consequences in practice. A question that cannot be answered on the basis of our research is how criminal law race protections are applied in practice. It seems to me that the snapshot we have here does not in practice always correspond to the reality. Gertner simply refused to concede that the Americans actually went so far as to prosecute miscegionists. He had no evidence for that assertion, but we should understand that he was doing his best to grasp at some argument that would deflect the impact of the American precedent. Gertner then returned to the question of anti-Jewish legislation. The United States, he reported, was not alone in refusing to engage in formal legal persecution of Jews. We have not been able to find race legislation aimed at combating the Jews in any currently existing foreign law among the states which were the object of our research. I believe that in order to find such legislation, we would have to go back to the law of the medieval German cities. It was true enough that there was no anti-Jewish legislation in the United States, but then there was no anti-Jewish legislation in any contemporary system. What was nevertheless interesting, much though Gertner wished to minimize it, was that America had produced the very sort of law that Nazi lawyers had gathered at the meeting to debate. It had taken the step of criminalizing race mixing in a great number of cases. After Gertner's presentation of the ministry's memo, the participants moved on to a variety of technical questions in the drafting of criminal measures. It is certainly not the case that America was the sole subject of discussion, even if it was the first. Nevertheless, it was not forgotten. References to American law continued to pepper the meeting. Most especially, the transcript reveals that as the morning wore on, the American example was highlighted by two of the more aggressively racist Nazis at the meeting, Freisler and Karl Klee, presiding criminal court judge and professor of criminal law at the University of Berlin, and another of the radicals who had worked on the Prussian Memorandum. It seems that the United States had particular attractions for the more uncompromising racists present. Thus, about two-thirds of the way through the meeting, Klee turned once again to Jim Crow segregation and its value for Germany. The question that concerned Klee was whether the new Nazi criminal law regime should be race-based, simply declaring the separation of the races, or racist, declaring the superiority of some races and the inferiority of others. Some Nazis had suggested that the new law should be purely race-based, avoiding any claim that Jews were inferior, they argued, would improve Germany's international public relations. Klee rejected that approach. The plain truth, he insisted, was that the German people were convinced that the Jews were an inferior race, and German law should say so openly. Here, Klee believed that America offered a valuable model. American race law, he argued, was unquestionably founded on a belief in racial inferiority. Like the Supreme Court in Brown v. Board of Education, Klee had no doubt that Jim Crow was designed to dramatize the inferiority of the black population. Klee viewed segregation as a form of Nazi-style race protection intended to alert the white population to the menace posed by blacks. Jim Crow, he argued, was the American equivalent of one of the principal race protection strategies Nazis were using on the German streets in 1933 to 1934, the boycott. Nazi stormtroopers aimed to educate and enlighten the populace by staging intimidating boycotts in front of Jewish shops. Under Jim Crow, Klee argued, Americans were doing the same thing, but on a grander social scale. American race legislation, too, just like German popular attitudes, certainly does not base itself on the idea of mere racial difference, but to the extent this legislation is aimed against Negroes and others, absolutely certainly on the idea of the inferiority of the other race, in the face of which the purity of the American race must be protected. This is also expressed in the social boycott that is mounted on all sides in America against the Negroes. Here was another striking Nazi interpretation. Segregation was the American version of the Nazi boycott. American racists employed Jim Crow law on all sides in order to raise American consciousness, just as Nazi thugs stood outside Jewish shops brandishing placards reading, "Germans, defend yourselves, don't buy from Jews." It was yet another case of Americans defending themselves against an alien race that was attempting to gain the upper hand and threatening to exert influence, and what the American example showed was that true race-based criminal law ought to be unapologetically racist criminal law. But by far the most dramatic exploitation of the American example came a few minutes later from Freisler, the judicial murderer in the service of Hitler. His intervention suggested that he too, like Gertner, had come to the meeting prepared to debate America, and with a detailed knowledge of the American case in hand. Freisler used the American example to mount a Nazi response to the objections of traditionally minded jurists like Lösner. It was a fundamental principle of traditional German law that criminal law required clear and unambiguous concepts. If judges were permitted to convict on the basis of vague concepts, the core requirements of the rule of law would not be met. Yet, so Lösner argued at the meeting, Nazi policymakers had failed to find a clear and unambiguous concept of a Jew. There was simply no accepted scientific means of determining who was Jewish. An effective means of determining whether a given human being has an element of Jewishness on the basis of his behavior or outward appearance, habitus, or blood or the like does not exist, or at least at present has not yet been found. That failure constituted an obstacle for criminalization. It was intolerable, Lösner declared, to allow every individual judge to make decisions on the basis of mere Gefühlsantisemitismus, of vague sentiments of Jew hatred. The indispensable prerequisite for proper criminalization was a clearly delineated and scientifically acceptable definition of who counted as a racial Jew. In any case, judges, Lösner added, must work within the limits of the presumption of innocence. These were basic requirements of legality, and they stood in the way of implementing the radical Nazi program. It was here that Freisler, showing typically bluff radical Nazi contempt for technical doctrinal concerns, countered by citing the United States. The problem, Freisler maintained, along with another radical companion, was not a scientific or theoretical matter at all. It was a problem that called for a purely primitive and political response, and American law was Freisler's model of the primitive and political. American law, he said, demonstrated that it was perfectly possible to have racist legislation, even if it was technically infeasible to come up with a scientifically satisfactory definition of race. Freisler went into intimate detail about the laws of the American states and the nature of American jurisprudence to make his point. Now, as far as the delineation of the race concept goes, it is interesting to take a look at this list of the American states. 30 of the states of the Union have race legislation which, it seems clear to me, is crafted from the point of view of race protection. And political, added another radical who had worked on the Prussian Memorandum. That is perhaps the case only with regard to the Japanese, but in other respects from the racial point of view. Proof. North Carolina has also forbidden marriages between Indians and Negroes. That has, after all, certainly been done from the point of view of race protection. I believe that apart from the desire to exclude foreign political influence that is possibly becoming too powerful, which I can imagine is the case with regard to the Japanese, this is all from the point of view of race protection. This American form of race protection, Freisler continued, did not trouble itself about the correct scientific conceptualization of race. Moreover, it is not the case that all states that have to reckon with the possibility of Japanese immigration have spoken of the Japanese, but some have spoken of Mongols, even though it is without a doubt the case that Japanese and Chinese are not to be assigned to the Mongols, but to an entirely different folk blood group. Why have these states done this? I cannot believe that they have done it just in order to delineate a concept. Rather, I believe that they have done it because they were targeting a kind of race image, Rassebild, and have only erroneously lumped the Japanese in with the Mongols. The same thing is shown by the way they list them, that is, the various races, all together. A state speaks of Mongols, Negroes, or mulattoes. That clearly shows that the racial point of view has been placed in the foreground. The bottom line is that the Americans in reality have first and foremost desired to have race legislation, even if today they would perhaps like to pretend it is not so. At any rate, he explained, the beauty of the American example was that it demonstrated, as American law so often does, that it was possible to manage a functioning legal system without the sorts of clear concepts German lawyers cherished. How have they gone about doing this? They have used different means. Several states have simply employed geographical concepts. One state speaks of African descent, another of persons from Africa, Korea, or Malaysia. Still others have conflated matters, combining geographical origin with their conception of a particular circle of blood-relatedness. For example, in the example I have just given, there is subsequently added, or of Mongolian race. Another state mentions both alongside each other. Nevada speaks of Ethiopians, or of the black race, Malaysians, or of the brown race, Mongols, or of the yellow race. That signifies a remarkable mixing of the system of geographical origins with conceptualization on the basis of blood-relatedness. Yet all this conceptual messiness did not prevent America from having a racist order. American legislation, Freisler argued, managed perfectly well with what might be called the political construction of race. It displayed an ideological determination to build a racist order even in the face of the absence of any meaningful scientific conception of race, and in that regard Freisler believed that Germany had something to learn from American legislative techniques. Nor was it just American legislation that had lessons to offer. Freisler further argued that there was something to learn from the techniques of American judging. American judges had no trouble applying racist law despite its fuzzy concepts. Indeed, if it were not for the lack of American attention to the Jewish problem, the American style of jurisprudence, Freisler declared in a resonant sentence, would suit us perfectly. These states obviously all have an absolutely unambiguous jurisprudence, and this jurisprudence would suit us perfectly, würde für uns vollkommen passen, with a single exception. Over there they have in mind, practically speaking, only coloreds and half-coloreds, which includes mestizos and mulattoes, but the Jews, who are also of interest to us, are not reckoned among the coloreds. I have not seen that any state speaks of foreign race as standard Nazi language would dictate, but instead they name the races in some more primitive way. The absence of an anti-Jewish jurisprudence did not mean, however, that American jurisprudence had nothing to teach Germany. What the American example showed was that German judges could persecute Jews even without legislation founded in clear and scientifically satisfactory definitions. Primitive concept formation would suffice. In fact, Freisler maintained, it would be perfectly workable if German race legislation, too, following the American lead, simply specified coloreds. It seems to me doubtful that there would be any need to expressly mention the Jews alongside the coloreds. I believe that every judge would reckon the Jews among the coloreds, even though they look outwardly white, just as they do the Tatars who are not yellow. Therefore, I am of the opinion that we can proceed with the same primitivity, primitivitat, that is used by these American states. A state even simply says, colored people. Such a procedure would be crude, roh, but it would suffice. Such was the attractiveness of the American common law model for this baleful figure, the avatar of the modern judicial butcher, a man guilty of a perversion of the forms of justice that was extreme even by the standards of the Third Reich. American courts did not allow themselves to be hobbled by some pedantic insistence on clear and juristically or scientifically defensible concepts of race. They just went to work. Even though America did not target the Jews, this American common law style of legal racism, with its easygoing, open-ended, know-it-when-I-see-it way with the law, had a primitivity that would suit Nazi judges perfectly. This was too much for Gertner, who responded to Freisler by trying once again to dismiss the usefulness of American models. Well, the idea that we could get anything useful from these American models cannot be exploited in practice since, as Herr State Secretary Dr. Freisler has already said, American law concerns itself with variance, with different nuances of the concept coloreds used now in this way, now in that, perhaps most clearly in the case of Virginia, which speaks of colored persons, including mulattoes, mestizos, etc. Such vague reference to coloreds was useless to Germany, Gertner insisted, and it was useless because there should be no general criminalization of racially mixed marriages. The only possible aim of the new legislation would be to criminalize malicious racial deception in marriage, and it was in the nature of things that colored persons were in no position to deceive others about their race. If our aim in the criminal law of race protection is to punish malicious deception, then the question of coloreds falls ipso facto by the wayside, since malicious deception on the part of coloreds does not seem to me very probable. The American question was thus sharply framed as part of the conflict between hardliner and moderate. Freisler, the champion of merciless criminalization and primitive rather than juristic decision-making, declared that the American approach would suit us perfectly. Gertner, the lawyer moderate still in the saddle in early June 1934 but destined to lose in the political battles of the coming year, insisted that there was no place for American models in the more modest and juristically conventional approach he advocated. The meeting included further references to American law that I will not discuss in full here. Among them, though, there is one exchange toward the end of the day that stands out. Erich Möbius, a Nazi doctor attached to the Interior Ministry, raised once again, sorrowfully, the difficulties caused by foreign objections to the criminalization of consorting with colored races, and reported memorably on a conversation with an American to which Freisler gave his own memorable response. Möbius's American acquaintance had observed that the Nazis' diplomatic troubles were caused by the explicit racism of the Nazi program, and asked whether it was necessary to be quite so open. Dr. Möbius: I am reminded of something an American said to us recently. He explained, "We do the same thing you are doing, but why do you have to say it so explicitly in your laws?" State Secretary Freisler: But Americans put it in their own laws even more explicitly. Indeed. Thus a stenographic transcript of a critical meeting planning what would become the Nuremberg Laws. The transcript is quite a striking datum in comparative law. It is rare indeed that we possess such an ingenious and detailed record of how the process of influence transpires. And needless to say, what the June 5th transcript records is not evidence of the astonishing insignificance of American law. American law was the first topic of discussion at the meeting, and it was mooted in notably well-informed detail by the participants, including numerous verbatim quotes from anti-miscegenation statutes from all over the United States. Moreover, the American example already highlighted by the Prussian Memorandum in September 1933 had clearly been a subject of discussion and debate before the meeting took place, so much so that the Justice Ministry had gone out of its way to prepare a detailed memo on the subject. In particular, it is clear that there had been debates over whether the importation of Jim Crow measures might not serve to educate and enlighten the German populace. Some moderates had advocated Jim Crow enlightenment as an alternative to criminalization, while a hardline figure like Klee thought of Jim Crow as a more broad-gauged version of the menacing Nazi boycott. Justice Minister Gertner was manifestly uncomfortable with American models, but he cited them nevertheless, sometimes in significant detail, just as Freisler did. Moreover, Gertner felt constrained to open the general discussion at the meeting by presenting the ministry's memo. In particular, he felt constrained to note that the American states engaged in the otherwise rare practice of the criminalization of racially mixed marriages. The meeting was certainly not by any means devoted exclusively to America, but the participants clearly took a serious interest in what they could learn from the laws of the American states and discussed them repeatedly, and it is unmistakably the case that the American example was pushed hardest by the radical faction, which lost out for the moment, but which would ultimately triumph at Nuremberg 15 months later. The transcript, be it said, does not record an effort at generating international propaganda by citing the American example. The participants unquestionably were worried about foreign policy considerations, but they were a drafting commission for criminal law, and the purpose of their closed-door meeting, and in particular of their effort to undertake the rather difficult business of collecting American law, was to find material for the making of their own Nazi legislation. All this certainly does not mean that the blood law was mechanically copied from the law of some American state, but it can hardly be written off. What it suggests clearly enough is that for radical Nazi lawyers in the summer of 1934, as for Hitler in the 1920s, America was the obvious preeminent example of a race state, even if it was one whose lessons were not unproblematically applicable to Germany. The bottom line is this. When the leading Nazi jurists assembled in early June 1934 to debate how to institutionalize racism in the new Third Reich, they began by asking how the Americans did it.